Welcome back to PHCodal channel. Okay, let's dive right into this thrilling corporate drama. We're looking at a high-stakes legal battle that absolutely rocked the financial brokerage industry and, honestly, sent ripples through the boardroom of pretty much every major corporation. This is the landmark Supreme Court case of Ient versus Tullett Prebon. If you've ever wondered what happens when aggressive business expansion collides with allegations of corporate sabotage and mass employee poaching, well, you are definitely in the right place for this explainer. Whether you're a dedicated law student grinding through your reading list, a bar reviewee looking for that extra edge, or a seasoned legal professional brushing up on landmark jurisprudence, we are so thrilled to have you here. Today, we're serving up a masterclass in corporate law, breaking down a genuinely complex Supreme Court digest into crystal clear, actionable insights. And to unpack this case, we're going to stick to our favorite structured method, the classic FIRR approach. That's the facts, the issue, the ruling, and finally, the reasoning. So let's kick things off with part one, the facts, the corporate rivalry. Picture this. On one side, we have Tullett Prebon. They've been established in the Philippines since 1995, and they literally reigned as the second largest interdealer brokerage group globally. Massive, right? Now, on the exact opposite side of the ring is the Tradition Group, coming in as the third largest globally. Tradition wanted a piece of that very lucrative Philippine market, so they decided it was time to establish a direct local subsidiary to compete head-to-head with Tullett, a real clash of the titans. And man, in just a few short months, a simple expansion became an explosive legal confrontation. Back in August 2008, James Ient and Ient Schulze were tasked by the Tradition Group to set up their Philippine subsidiary. But then, almost simultaneously in late August, Tullett Prebon suffered a totally devastating blow. We're talking a mass resignation of its brokering staff. And Tullett alleged this was orchestrated by their own former executives who were jumping ship to Tradition. By September, Tradition Philippines was officially registered with the SEC. And by October, well, Tullett struck back hard, filing a massive criminal complaint. Now, the absolutely crucial point to understand here is that Tullett didn't just sue for civil damages. Oh no, they went straight for the jugular. They sought actual criminal charges against their former executives and the Tradition Group leaders, including Ient and Schulze. Tullett claimed these folks basically engineered a mass resignation that amounted to straight-up corporate sabotage. They specifically alleged violations of Sections 31 and 34 of the Corporation Code. You know, the sections dealing with fiduciary duties and loyalty of directors? Yeah, those. Plus, they claimed the defendants conspired under the revised Penal Code. Tullett basically used Section 144 of the Corporation Code, which is kind of this general penalty provision, to argue that these executives belonged behind bars. And the wild part? The Department of Justice actually agreed and found probable cause to indict them. Which leads us straight into part two, the issue. What is the core legal question here? Simply put, can corporate disloyalty and employee poaching actually land you in a jail cell? Let's recap real quick. Section 31 covers bad faith and gross negligence by directors, and Section 34 covers acquiring corporate opportunities. Section 144, on the other hand, is this catch-all provision stating that violations of the code shall be penalized. But does that penalty mean prison time for a breach of fiduciary duty? This was seriously uncharted territory. And let me tell you, corporate directors everywhere were holding their breath waiting for the answer. All right, part three, the ruling. Let's look at the court's decision. It is a resounding no. The Supreme Court gave an absolute and definitive negative to the prospect of criminal liability in this specific scenario. They ruled that violations of Sections 31 and 34 of the Corporation Code are not criminally punishable under Section 144. I mean, you can practically hear the collective sigh of relief from corporate boards across the entire country. The court's formal holding completely overturned the Department of Justice's pursuit of criminal charges. The DOJ's directive to file informations against the executives was totally reversed and set aside, so the threat of prison for these specific acts of alleged corporate disloyalty entirely removed from the table. Gone. So how did they arrive at that conclusion? Let's jump into part four, the reasoning, and exactly how the court interpreted the law. Well, it all hinges on this fundamental legal maxim, the strict construction of penal laws. The Supreme Court emphasized that when life and liberty are quite literally on the line, criminal liability must be clear and certain, no guesswork allowed. Any doubt whatsoever in how a criminal statute is interpreted has to be resolved in favor of the accused. Actually, scratch that. You can never mechanically apply penal laws like a robot. You really have to dig in and look at the actual legislative intent. The court made a really solid point here. They noted that sections 31 and 34 explicitly contain their own remedies. Think about it. If a director acts in bad faith or straight up steals a corporate opportunity, the law already says they are liable for damages and accounting of profits and restitution. Because the legislature specifically took the time to write in these civil and financial penalties, the court reasoned they definitely did not intend to just slap on the general criminal punishment found in Section 144. It just wouldn't make sense. The court's wording perfectly captures that. There is just a lack of clear legislative intent to jail directors purely for violating their fiduciary duties. The court even compared the corporation code to other laws, like the Omnibus Election Code, where the legislature used very emphatic, undeniable language to declare certain acts as criminal offenses. But the corporation code? It lacks that definitive language for sections 31 and 34. Without that crystal clear intent, the court basically said, look, we're not going to stretch Section 144 to create a crime out of thin air where the legislature didn't explicitly write one. And that brings us to the end of this deep dive. Before we leave you with a final thought to mull over, please make sure to like, comment, and subscribe. Engaging with the channel really helps us continue to bring you these structured, high-yield legal explainers to support your ongoing studies and professional practice. Oh, and definitely let us know in the comments what case you want us to tackle next. To wrap up, I want to leave you with this somewhat provocative final thought. Where exactly should the law draw the line between aggressive business expansion and illegal corporate sabotage? I mean, the Supreme Court ruled out criminal jail time for these specific fiduciary breaches, but it didn't excuse the behavior, right? It just said the battleground should be civil court fighting over damages, not criminal court fighting over a person's freedom. In a fiercely cutthroat corporate world, is the threat of paying financial damages really enough to keep executives loyal, or does the system actually need the threat of a cold, hard prison cell? It's a fascinating question about the very limits of legal punishment. Thanks so much for learning with me today, and I'll catch you in the next explainer.